Good morning. This is Jennifer Prell with ElderWorks. Welcome to our series on the hidden heroes, veterans, and caregivers topics this week. This morning we have Molly Kosbab, Supervisory Field Examiner from the Department of Veterans Affairs Fiduciary Hub, speaking about VA Fiduciary Program. Just a quick reminder, if you have any questions, please put them in the chat and we will make sure that the questions get answered at the end of this program. So please welcome Molly Kosbab. Thank you, Molly.
Hi, my name is Molly Kosbab. I am a Supervisory Field Examiner with the Milwaukee Fiduciary Hub. Today we are going to be talking about the VA Fiduciary Program. The Milwaukee Fiduciary Hub is responsible for a total of 7 states. That includes Wisconsin and the Upper Michigan, Minnesota, Iowa, Missouri, Arkansas, Louisiana, and Illinois. As you can see in the map, it's pretty much a central all the way down parts of the U.S. Note that we currently do not oversee the northwest corner of Minnesota. That is part of the Lincoln Fiduciary Hub. The program responsibilities are to access, competence, and personal welfare of the veterans and beneficiaries. What this means is our field examiners pre-COVID did actually one-on-one, face-to-face visits with our veterans and beneficiaries prior to appointing a fiduciary, and just to assess whether or not they are indeed unable to manage their own financial affairs. If they need, additional assistance within the house, what additional responsibilities a fiduciary may also need to help the beneficiary with. We determine the payee best suited to meet the needs and situation of the beneficiary. Typically, we try to appoint the payee that the beneficiary prefers, but that's including that they are able to pass a background and a credit check. We arrange for the utilization of the benefit funds. For example, if they are only in receipt of $100, we will, instruct the fiduciary typically how to spend that $100, because we know $100 won't be able to pay for all the beneficiaries' bills. Versus if they were 100% service connected and receiving well over $3,000 a month, the fiduciary may be responsible for paying most of the beneficiaries' bills. We protect assets from loss or diversion by putting them in properly titled accounts. We assure the entitlement rights of the beneficiary. If the field examiner notices that they might be able to apply for a higher benefit, the field examiner will assist with that process. We also act on the behalf of supervised direct pay beneficiaries, and these are beneficiaries that our field examiner will determine on a temporary basis if they can handle their own financial affairs. What is a fiduciary? A fiduciary is a person or legal entity charged with the duty of managing the estate of a veteran or beneficiary who is unable to manage their financial affairs. So basically someone who is unable to pay their day-to-day bills and needs assistance in that matter. Our fiduciary program definitions, we do use the word incompetent, and I know that upsets many of our veterans and beneficiaries. However, that is what the legal terminology is according to the regulation below. So that is any minor who might be in receipt of benefits, or an adult who is rated unable to manage their financial affairs by VA or under illegal disability by reason of court action. Included in this are veterans' children who are shown to be permanently incapable of self-support on the date they become age 18, otherwise known as helpless adults. According to the Code of Federal Regulations 3.353, the determinations of incompetency and competency. So that is where that word incompetent is still from. It's still in our regulations. Definition of mental incompetency is a mental incompetent person is one who, because of injury or disease, lacks the mental capacity to contract or to manage his or her own affairs, including disbursement of funds. VA incompetency. So one of the most common questions we get as supervisors is, what is needed to start the process? First of all, medical evidence or court appointment is first needed. So if a doctor deems a veteran or beneficiary incompetent, then we request that that medical evidence be sent to the Lakeland, Florida Intake Center. And we will have the address up later where that documentation needs to be sent to. It is crucial that a cover letter on VA Form 21-4138 be sent along with the medical evidence, specifically requesting the appointment of a fiduciary. We request the 4138 because most of our processes are now automated. So when that information is scanned into the system, if it does not include a VA form, it does not necessarily get lost in the system, but it doesn't automatically get assigned a task or end product is what we call them, to look at the information. So that's why we wanted, because of it's an automated system, we want to include the VA form 21-4138, so the system automatically acknowledges that something needs to happen. One thing we want to make note of is that the beneficiary or veteran must have a medical condition that justifies being rated unable to manage their financial affairs. For example, the veteran just continues to make bad choices with their money, for example, alcohol over buying food, and does not have a medical condition that causes them to do so. For example, PTSD, dementia, the list is, it goes on and on. So it does not have to be related to those couple issues, but it has to be a medical condition. So if they do not have a medical condition, this does not justify the need for a fiduciary. So in this case, we request that a power of attorney be found instead. That is something that the VA does not appoint. We do not appoint power of attorneys. So just one important note. If a veteran or beneficiary gives you court appointment papers, we also want those to be sent to the Lakeland, Florida Intake Center. If those that have court-appointed papers for a court-appointed guardian do not need to necessarily have to have the medical evidence to go with it. So we want to make sure that the veteran's full name and VA file number is in all pages. If you do not know what the VA file number is, you can always substitute it with the veteran's full Social Security number. Again, it's the veteran's Social Security number and not the beneficiary, which could be a surviving spouse or one of his children. It could also be considered a beneficiary. So we want to make sure that you have access to the veteran's full Social Security number if you do not have access to the VA file number. Let's talk about Brady Bill. The Brady Handgun Violence Prevention Act prohibits anyone rated unable to manage their financial affairs from purchasing, possessing, receiving, or transporting a firearm or ammunition. Beneficiaries may be fined and/or imprisoned for violating this law. Many of our beneficiaries become upset once they find out they can no longer hunt and/or possess firearms, whether they are a collector or just want it for protection. However, we always notify those that a beneficiary may apply for relief. So if they are an avid hunter, they can always apply for relief from the Brady Bill. Next, we're going to talk about supervised direct payee cases. Supervised direct payee cases, otherwise known as SDP, pays a beneficiary directly even though they are rated incompetent by the VA. This is a temporary payment method not to exceed 6 months in length. So that's typically we appoint somebody as SDP when the field examiner assesses the beneficiary or veteran and notes that they appear to be able to handle their own financial affairs. For example, a common thing where we will appoint somebody as SDP is on one of the medical forms that a VAMC doctor typically gets. One of the questions is, do you handle your own financial affairs? When asked, many veterans, especially our older generation veterans, may say, no, my wife handles it, or no, my husband handles it. Well, if the doctor marks it down as no, they are unable to handle, they don't handle their financial affairs, that is an automatic rating for incompetency. So typically once a field examiner meets with our veteran or beneficiary and explains, and they are confused as to how they even got involved with this, they typically look to see it, hey, who pays your bills? Did you mention it to your doctor that maybe you don't pay them? Maybe your spouse pays the bills. And they say yes. Then typically the field examiner will appoint the veteran or beneficiary as SDP. So we must receive a competency statement or assign a payee after 6 months. We cannot extend this more than 6 months. All retro payments are withheld during this period. So if the veteran or beneficiary is entitled to a back pay, we cannot pay this during while they are appointed as SDP. The VA monitors beneficiaries and SDP status on a monthly basis. So basically, our field examiners talk to the veterans or beneficiaries that are rated or that are appointed as SDP on a monthly basis, check in and see what the status is of them getting a competency statement from their doctor. The individual fiduciary requirements, what we do in order to appoint a fiduciary. First, we do a thorough background check, make sure that they are, do not have any felonies. Second, we do a credit check. If their credit is poor and below a certain credit score, we will not appoint them. Or if there's signs of bankruptcy that is unexplainable, they will not be appointed. They also there may be a possibility of a surety bond requirement, so they need to be able to go and obtain the surety bond as well. They may also have to do an annual accounting, which we'll discuss further. So the field examiner needs to assess the fiduciary to ensure that they themselves feel confident and would be able to do an annual accounting, which accounts for how the VA benefits are spent on an annual basis. The standard form for completion for a federal fiduciary. So when our field examiners go out and prior to appointing a fiduciary, they take the form VA Form 21P-4703, which must be signed by the fiduciary. This form is an agreement with a budget agreement included. So it's an agreement. It states, for example, you will not take cash withdrawals, you will not transfer funds out of the properly titled account into another bank account. So it lists all the rules that the fiduciary needs to comply by. It also includes budget agreement. Budget agreement is typically what the main bills are for the veteran or beneficiary, and how the fiduciary is to associate the VA funds, or basically pay the VA funds with those bills. Again, like I mentioned earlier, if the less amount of VA funds that they get on a monthly basis, the less bills that the fiduciary will be required to pay. Allowable fee when authorized. So fiduciary fees may not exceed 4% of the amount of VA benefits paid in 1 year of period. So basically, a fiduciary, it may be entitled, that has to be approved by a field examiner to get a fee for managing the beneficiary's funds. We will not approve a fee for a family member, for example. These are fiduciaries that are what we call professional fiduciaries. There are fiduciaries that are out in the community that for their services, they are given a fee to manage the VA benefits funds. A fee cannot be taken from the beneficiary's retroactive payment. Also, 38 CFR 13.220B3I talks more into detail about the VA allowing fees for our professional fiduciaries. A surety bond will be required when the VA estate exceeds $25,000. So the bond amount is reviewed annually to coincide with the annual accounting. So, for example, some of our veterans who may be in the veteran's home and have their care completely paid for in a veteran state home, for example, if they may be in receipt of 100% service-connected benefits, their bank accounts tend to, add up every month after month, because they really don't have a lot of additional expenses because their expenses are all being paid for. So that might be a case, for example, when they might need to obtain a surety bond because their monthly benefits will eventually reach more than $25,000 in one account. So we want to make sure that the fiduciary is able to obtain a bond, and a bond is basically an insurance protection. So if our fiduciary is found to misuse benefits or misuse, the funds that they are entitled to, that bond company will then repay back the veteran or beneficiary the amount that was found to be misused. Legal investments for federal fiduciaries. So the only accounts where our federal fiduciaries can put the VA monies into is a properly titled U.S. savings bond, an interest-paying account protected by FDIC. That is 38 CFR 13.210. Talks about, again, how we need to properly title the account as well. So this means that a fiduciary cannot put the VA monies into like the stock market because the stock market is risky. We can only put it in safe accounts without any risk. And I mentioned earlier about the possibility of doing an annual accounting. An accounting is the fiduciary's written report of his or her management of beneficiaries' income and estate. It consists of a beginning inventory, an itemization of income and expenses, and an inventory of assets remaining at the end of the accounting period. So basically a detailed report of how what income from the VA came in and all the expenses that were paid over the 1 year period. The requirements for a federal fiduciary accounting: the VA estate must be $10,000 or more, or the annual VA benefits is equal to or in excess of the single 100% service-connected rate. Those are typically a lot where we see the most of our accountings. Otherwise, the VA appointed fiduciary is receiving an authorized fee from the VA benefits payable. So any of our professional fiduciaries that are in receipt of a fee, again, 4% or less per month, those would also have to do an annual accounting. Fund usage reviews. The fund usage reviews came out about 1 year ago. So these are very new within the Fiduciary Hub. And of a lot of our fiduciaries haven't quite received one yet, or these are very new, and we're helping our fiduciaries learn how to process these. So for example, what is a fund usage review? A fund usage review consists of 3 months of all financial statements containing VA funds for each beneficiary that the fiduciary manages. So our fiduciary will get a letter in the mail stating you need to submit 3 months worth of bank statements. They will also include the specific time frame for which the 3 months of bank statements needs to be for. And they also must submit a copy of canceled checks along with it. And it's submitted on a biannual basis. So every 2 years, a fiduciary needs to submit a fund usage review. And who is required to submit a fund usage review? So all fiduciaries are required to submit a fund usage review by the hub unless listed as the following exception. For example, they already are required to submit an annual accounting. They will not have to do a fund usage review. If we appoint a spouse fiduciary, so basically the only ones that can have a spouse fiduciary, of course, are veterans. So if the veteran spouse is appointed as their fiduciary, they do not have to account by doing a fund usage review. Or a fiduciary who is a chief officer of a federal institution or a non-VA facility receiving benefits for a beneficiary residing in the facility. So basically, if a veteran is in a VAMC, that is typically what is meant by the federal institution, or another federal institution may be considered a prison. And we have not seen one yet where we monitor one that falls into the prison situation, but that is another example of a federal institution. Our more popular ones are the non-VA facilities. Those are nursing homes, assisted livings, community care homes, things like that. If we appoint the administrator of one of those, they do not have to account by doing the biannual fund usage review. So proper account titles, I know I touched on this a little earlier, but all accounts where the VA monies are put into must be established conveying the fiduciary relationship. For example, I must state guardian of, or conservative of, or federal fiduciary of. It must connote that relationship. One of the things that is coming out now with our fund usage reviews, which is kind of different than what previously, we need to make sure even the checks that the fiduciary has shows the proper account title. Just because an account might be titled properly doesn't always necessarily mean that the fiduciary titled the checks that way. The fiduciary might just have put their name on it, for example, and not put, that they are a federal fiduciary for someone. So that is causing an issue with some of our fund usage reviews. That's pretty much one of our main issues. So that's something that is new that we are trying to educate our fiduciaries with also getting their showing the relationship on their checks. So let's talk about power of attorneys. So remember, the VA does not recognize a general or durable power of attorney as evidence that a VA beneficiary is unable to manage their financial affairs. So the VA must have either medical evidence showing the beneficiary is unable to manage their financial affairs, or a copy of a copy of a court appointment of guardian of person. So again, we do need to either have the medical evidence that they're unable to handle their financial affairs, or the court appointed paperwork in order to appoint a fiduciary. Our promulgation team. So our promulgation team is something that we've had for several years now, hasn't always been part of the Fiduciary Hub. But after the proposal to rate the beneficiary unable to manage their financial affairs, the case will come to the Fiduciary Hub for further processing. The Fiduciary Hub will rate the beneficiary unable to manage their financial affairs after a 60-day due process period. We will issue the request for fiduciary appointment, select the payee, and process the award for payment. So one of the common questions that I get, especially from social workers who call a lot, that they want somebody appointed almost immediately. They say it's a dire situation. Our veteran he desperately needs a fiduciary appointed. We need to explain that although we may be able to expedite proposing the rating of incompetency, the veteran is entitled to the 60-day due process period. The veteran or beneficiary can always waive that 60-day period. They can't waive it before the proposed rating. So once they get the letter in the mail, they can always waive it, but we have to give them that. I explained to many of our social workers that no, we have to wait, or if you guys can talk to the veteran and try to get him to waive the due process, we can certainly make it quicker. Our timeline goal, so once due process expires, we have 10 days to complete the final rating, 33 days to complete for the field examiner to complete the field examination, and 14 days to release the retro. So we have a total of 57 days, and we are well under the total of 57 days. So typically the longest part of the process of getting a fiduciary appointed is once that medical evidence is submitted to the Lakeland VA Intake Center, which the address will give out later on the slideshow. So that's typically the longest time period, but because we are doing the national work queue and it can be worked by anyone in the country, they are being worked quite faster as well. So that's typically the timeline for getting a fiduciary appointed. So a common question we get is, what's the difference between a fiduciary versus a guardian? So the VA appointed fiduciaries are only in charge of the VA funds and ensuring bills are paid on time. It is not their responsibility to ensure food is in the fridge, the home is clean and safe, etc. So that just because it's not their responsibility doesn't mean that a lot of our fiduciaries don't take on that extra role, especially if they are family members. Of course, family members would want the best for their family member. And even some of our professional fiduciaries take on extra responsibilities, even though the VA does not necessarily expect them to do so. However, nothing prohibits a fiduciary from petitioning the courts for guardianship. Some of our professional fiduciaries actually do prefer to be the guardian as well. Or even if they don't pursue guardianship, a lot of our professional fiduciaries will go to Social Security and ask to be the Social Security payee for the veteran or beneficiary. Let's talk about misuse or misappropriation of VA funds. So misuse or misappropriation of VA funds is typically, if one of our fiduciaries, if the veteran or beneficiary suspect that the fiduciary is not utilizing their funds for their purposes, they might feel that they are stealing their funds, or they might have evidence of so stealing. We want to make sure that they submit a written letter to the Lakeland Intake Center for further investigation using VA Form 21-4138. Have the veteran or beneficiary sign the letter if possible. Include as many details as possible. If there is additional evidence to support it, submit that along as well. Include the veteran's full name and VA file number on all pages. Again, if you don't have the veteran's VA file number, have the veteran's full Social Security number. and you're going to send this all to the Lakeland Intake Center. You can also call the Milwaukee Fiduciary Hub toll-free number to report this information. Again, you have to have the veteran's full name and VA file number available. I'll discuss and provide the toll-free number a little later on. The next step, once we receive that information, is a VA, regarding misuse, is a VA employee on the misuse team will review the allegation of misuse. If the employee deems it appropriate, they will request that a field examiner complete an investigation. The field examiner has 54 days to complete the investigation and submit their findings. Next, we'll move on to another common question is, all right, maybe the veteran or beneficiary don't feel that they are incompetent, or maybe they had a medical condition that has gotten better, and that has been the case in many circumstances. So what is needed in order to get the veteran or beneficiary rated competent is just a statement from a physician. For example, Mr. Jones is capable of handling his own VA affairs. Have the statement sent to the Lakeland Intake Center. So again, it's just like a simple statement from a physician. It can be a nurse practitioner as well. Doesn't have to be like a doctor. What it can't be is a social worker, for example. They do have to have that kind of medical degree. So like a doctor, nurse practitioner, in that kind of field. So we're going to send the medical evidence of incompetency to the Department of Veterans Affairs, VA Fiduciary Intake, P.O. Box 95211, Lakeland, Florida 33804-5211. We want to again ensure to include the veteran's full name and VA file number on every page. Ensure a cover letter goes along with it on the VA Form 21-4138, specifying the appointment of a fiduciary along with the medical evidence is submitted. Do not include any medical evidence of inability to manage affairs to the Milwaukee Fiduciary Hub. We do not process those. So if you submitted those directly to the Milwaukee Fiduciary Hub, that would cause a delay. We don't really have too many going to the Milwaukee Fiduciary Hub anymore. We've been with Lakeland for a few years already now, but we just kind of want to emphasize, don't research like the regional office for Milwaukee, what the address is, and have it sent there. We still have, mail that goes to the regional office and that we got to forward down to Lakeland, Florida. So we don't want a delay in any mailing process. That's why we say submit it straight to Lakeland. The Milwaukee Fiduciary Hub contact information. Please provide this information to veterans or beneficiaries. That's the Department of Veterans Affairs, VA Fiduciary Intake, P.O. Box 95211, Lakeland, Florida 33804-5211, or our toll-free number is 888-407-0144, option number 5. Our toll-free number is for fiduciary issues only. I know, some people may have the assumption that the toll-free number has long wait times. I can tell you our wait time is less than a minute. On most days, it's less than 30 seconds. So definitely provide this information out to the veterans, our beneficiaries, fiduciaries regarding this. But again, we only answer questions regarding the fiduciary. We don't answer questions regarding benefits. So if they have a question regarding benefits, they will have to contact the benefit center. These are some of our great resources regarding the fiduciary program. If you look at the www.benefits.va.gov, that's got great information regarding the fiduciary program. Our VA handbook That's also a great program. We used to be able to get hard copies and could get those out to our fiduciaries. Unfortunately, they do not make hard copies of those anymore. Same thing with the fiduciary guide. Those were great to just be able to hand out at all of our appointments. Fortunately, everything has gone online. So we do give this information out as well, but these are some great resources and great websites to go to learn more and more detailed information regarding the fiduciary program. So thank you so much for joining me today. I hope you have learned a lot of different information that you may not have known regarding the fiduciary program. Thank you and have a great day.
Thank you so much for that. That was wonderful. We have Lisa Mims with us today to answer some questions. So hopefully we get some questions. Otherwise, I'll just ask all of mine. Lisa, you're muted if you want to unmute yourself. And then we can get started. We did have a question from Adina Bam. If a veteran doesn't have family, how do they get a professional fiduciary?
So the local field examiner who contacts the beneficiary and is in charge of responsible for appointing the fiduciary usually has contacts for professional fiduciaries that live in the state and out of state. So it just usually depends on who they have available and that they may think is a good fit for the beneficiary.
So what if the veteran doesn't have someone to speak on their behalf? Who would step up for them, like the Veterans Assistance Commission or a doctor? Who would call for help?
It could be a POA. It could be a family member, a distant family member. It could be a medical professional if they're seeing their VA doctor and their doctor recognizes that there may be some issue with being able to pay bills, then that will get sent over to us and we will start that process at that time.
Okay, so since the VA doesn't recognize power of attorneys for this process, if a power of attorney reaches out and they're able to be the fiduciary, would they be assigned as fiduciary or would they be a professional only assigned?
It would definitely depends. When we go about appointing our fiduciaries, we have to do a credit check. There's a number of things that we have to do, but they have a POA that might be a distant relative. They can possibly be a fiduciary. They may not be able to be approved for a fee, so to speak, but they definitely could possibly, if they fit the qualifications, be appointed as a fiduciary. When we talk in terms of POA, VA that we communicate with, it could be like American Legion. It can be those type of CVSOs that we communicate with as well. That the beneficiary may have delegated to be able to speak on their behalf when it comes to VA benefits.
Okay. All right. I don't see any other questions. So I'm just I have pages of notes. Oh my gosh. Hopefully people that were watching took as many notes as I did. It is kind of crazy. So let's see here. The VA fiduciaries you said are local to the person. Are those going to be like a professional financial organization? Are they VA representatives? Who would the VA assign? Who are some examples other than family?
It could be a banking institution. We've had those. It could be, we have some professional, and what made them professional is that we found that they have met all the criteria, background check, credit check, and they might live in another state and manage more than one beneficiary, and they're usually paid some type of fee, 2%, 1%, and we deem those professional fiduciaries. So most field examiners have built up um, I don't want to say like a kind of like a book of professional fiduciaries in the area that are willing to take on other beneficiaries. So, once they're working in that field, you might meet a fiduciary that may be a very good fiduciary for their father. And we might say, hey, are you interested in being a fiduciary for other veterans or other beneficiaries? And if so, then we will reach out to you if we need to, if we can't find a family member that's appropriate. It is always our goal to find someone close to the veteran or the beneficiary to be the fiduciary. That is our first goal. If not, then we'll go ahead and reach out to one of our professional fiduciaries.
So if a guardian ad litem is assigned to a person, would you consider that guardian ad litem their VA fiduciary maybe? Or
No,
no, totally
no,
separate?
yes.
Okay. All right. You just don't know. It's such a different world, the veterans world versus the rest of the world.
Right. Even like
I'm
court
just getting
appointed.
alerted all.
Yeah. No, no
Yeah.
worries. Feel free.
Okay. All right. Let's see here. Oh, good. Here's one. Another question. Is there a form that needs to be filled out as a delegate, excuse me, for that veteran?
When you say a delegate, do you mean for VA benefits? Is there a form that needs to be filled out? Let's say if there's a family member, a daughter, or a mother that wants to help, like the veteran on beat. Yes, there is. And
Okay.
usually that form has to be completed before the veteran is deemed incompetent. Once they're deemed incompetent, they really cannot go ahead and submit that form. So that's
Hmm.
one of the things that um, we have beneficiaries do, or if they're working with the local CVSO, the CVS knows that, hey, you might want to get a delegate or someone that can help on your behalf, which means that they can have access to your file number and to be able to call on behalf to follow up with a claim and things.
Oh, okay. All right. Because I am my father's delegate, I think. They contacted me at the VA.
Yeah.
Good. So I'll have more jobs to do in the future. Wonderful. I have so many jobs. It's crazy. Okay, let's see here. I'm just proper account titles. What was my question here? Why do we need proper account titles on the checks? So that's the question. On the
we
checks, are they creating a checking account with that title on it, or are they just signing it as?
They're creating a checking account with that title on there. It's really important for that the account to be titled properly, because once the beneficiary or the veteran is appointed a fiduciary, we that is stating that they cannot manage their funds, which means we do not want them to have access to that account with those VA funds in it. So if
Okay,
it's properly titled, then the veteran can't just come in and withdraw all the money. So that is
which makes
why
sense.
it is important that it is titled correctly and the checks match that. But we've had instances where um, the fiduciary failed to, let's say, set up that properly titled account, and the beneficiary was able to get access to that money. And that is what we are. We are attempting to not have happen. That's why they have a fiduciary, because they're not able to manage those funds. They could give it all away or do X, Y, Z with it.
We've seen that.
Yeah.
So, unfortunately, so if there's a fiduciary for the veteran and they properly build that account, would the bank then go, huh, maybe they need someone watching the other account? Or would they just make sure that the power of attorney was in charge? Do you know anything how to protect them for their other assets?
Good question. So, normally the bank will only operate as it's set up. So, if you have one properly titled account, and let's say the veteran is still have access to their Social Security, for instance, that's totally fine. Maybe the veteran has a problem with accessing a lot of money, right? Managing a lot of versus a little money. More cases than not, that is not the case, but normally we'll have a fiduciary that's managing the VA funds. If we have get wind that there may be some issues with that Social Security account, we will go ahead and report that to Social Security so that maybe they can see about getting someone to manage that account. And it could be the same fiduciary that we use. The Social Security can go ahead and appoint, or they can go ahead and appoint someone different. Um, if the fiduciary that we have is managing a Social Security account and a VA account, we VA would only be concerned with making sure that that VA account is, being used for the benefits of the beneficiary.
Hmm. That poses a lot of interesting issues.
Yeah.
We have a lot of we've worked with thousands of seniors, as you know, at ElderWorks, and we do find that there's unscrupulous people who take advantage of our seniors and our veterans, which makes me very angry, but we like to put them in jail. But what happens if a banker does notice that someone is fraudulently getting into an account, VA or otherwise? What are the steps at that point to protect that veteran?
Once we get wind of something like that, we start a misuse investigation. And once we start a misuse investigation, normally, if it doesn't, depending on if creates a hardship or not, we will put a suspension on the VA benefits to stop benefits for continually going into that account. Then we'll begin investigating the fiduciary and the account from that point on. If we find that there is some mishandling, we will swiftly remove that fiduciary and appoint a new fiduciary and continue to work on that misuse investigation on that old fiduciary. So we do have a really tight knit process because that does happen, unfortunately. And our goal is to protect the veteran, the beneficiaries, VA funds, all funds. So if we get wind of it, there is a process. We have referred misuse over to Social Security in the past and got things, both accounts shut down in order to make sure that the beneficiary wasn't being abused financially.
Wow. Yeah, unfortunately, you probably have fun with that. That's not something anybody wants to handle. I did have a question, and it just went blip 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 blip. It was about the misuse of funds. Oh, if the VA assigns a professional fiduciary and there is misappropriation of funds and the VA steps in, would that veteran get those funds back, or are those funds now gone because of the misuse?
We definitely go after getting those funds back to the beneficiary every single time. Sometimes, depending on how much is in place, which is why we have, for large amounts, we have that bond protection. And also, when the estate is at least 10K, we have that accounting. So we really try and keep really tight reins on that financial when we have a professional. And then we have annual audits on professional payees, because sometimes they're managing at least 5 beneficiaries. So they have to keep really tidy accounts, each individual fiduciary. So we're managing those individually as a whole when a fiduciary has multiple beneficiaries that they're managing. So yes, most times we will go after that fiduciary, and the funds are normally replaced. I mean, it might be a drawn out process, but we do go back to gather all those funds for the beneficiary.
Good. That's good to know.
Absolutely.
Okay, let's see. Any more questions here? I don't see any other questions. I'm sure I'll think of something when we hang up and go away, right? That's always
You can always email me.
So ElderWorks will be posting this presentation on our website. And if anyone has questions, your number and website and all of that's on there. Also, since you aren't printing books, a lot of our seniors that we work with don't have computers. So they can also come and see us, and we will print them for them or sections that they need. So if you ever have anyone in Northern Illinois who needs some help, we can help them. We can't help in Minnesota or Northern Wisconsin, but
we do appreciate all the work that you do and just giving us the platform to share this information, because what we want to make sure is that seniors and beneficiaries who get benefits from the VA, that there are ways to, help and make sure that they're protected. Because a lot of our claimants have dementia and different things like that. So it's not that, there's anything wrong with them other than, forget and can't manage as normal. So we want to make sure that, they're being taken care of. So thank you.
Absolutely. No, thank you. We appreciate all that you do. And if anyone has questions, Lisa can be reached at the number and the email that was previously shown. We will put that on our website. Thank you, Lisa.
Thank you so much.
Bye-bye.
Bye.